Robbery defense lawyer. Robbery is theft accomplished by violence or the threat of violence. Unlike theft or burglary, the crime of robbery almost always requires the presence of a victim who is threatened with bodily harm. If a weapon is used, or the victim suffers an injury, the robbery may be charged as armed or aggravated robbery. For example, Diane sneaks up on Jesse, demanding Jess's money while pressing a plastic object into his back. Jesse gives up his wallet. This would be charged as a robbery. If Diane used an actual gun, or Jesse was injured, the crime likely would be elevated to armed robbery or aggravated robbery. The element of force sits at the core of the crime of robbery. The timing of the force matters too. For example, if a thief uses violence only when attempting to flee the scene, the charges would include theft and perhaps assault, but not necessarily robbery. The use or threat of force can be slight. A robbery has occurred if a small amount of violence or intimidation is enough to coerce someone to turn over property. Physical differences between the robber and the victim, size, age, disability, would be considered in the analysis. A thief must not necessarily use great force to commit a robbery. A common purse snatching is a good example of how rules vary from jurisdiction to jurisdiction. Some states, such as New Jersey, require the use of force to increase the danger for the victim. In other states, like Maine, juries can conclude that the force used to grab the purse could satisfy the use of force element of the crime. For more information and a free criminal defense consultation, please call 480-436-2396 or visit us online at www.oliversonlaw.com.